Good afternoon. My name is Diane Varg. I'm with Family Partners of Morris and Sussex, and we welcome you to this week's Lunch and Learn. Today is September 26, 2024. Our presenter today is Yvonne Larson with Legal Services of Northwest New Jersey. Welcome, Yvonne.
Thank you. So just as a introduction at what Legal Services of Northwest Jersey, we are actually located in 5 northwestern counties. That includes Morris, Sussex, Hunter, and Somerset, and Warren. We have local offices in each county. And I'm covering public benefits here today, but we have various areas of law that our office handles: housing, consumer, autonomy, which for our office means wills, trusts, powers of attorney, as well as criminal record expungements. We handle public entitlements. We recently launched or are launching a new team, which technically falls under public benefits, but is a separate team for unemployment insurance benefits. We're not accepting cases yet, but it's something that's in the works right now. And we also have a family unit as well. So let me just make sure I know. Okay. A quick disclaimer that we give in our presentations is that this visual aid is only for the purpose of sharing information with the community about LSNWJ services and the law as it may apply at this time. The law is constantly evolving. Information you find in this aid should not be used as a substitute for the advice of competent legal counsel based on your specific circumstances. So to that end, if someone that you are working with is facing any of the legal issues that we cover, kindly just refer that person to our office for more specific legal advice. You should not act or rely on any information in this visual aid without seeking the individualized advice of an attorney licensed to practice law in your jurisdiction. Your attendance at an LSNWJ community education presentation or use of visual aids provided does not form an attorney-client relationship between you and Legal Services of Northwest Jersey or its representatives. Do not email confidential information unless or until Legal Services of Northwest Jersey agrees to provide you with legal assistance. LSNWJ accepts clients only in accordance with certain internal procedures. Do not share your confidential information outside of those procedures. Any information shared publicly in a community education forum is not confidential and is not subject to attorney-client privilege. Okay. So we will discuss generally the cases that LSNWJ handles, which are the following areas under public entitlements: welfare cases that fall under Workforce New Jersey, emergency assistance, which is also a welfare program, a social service program, SNAP, also known as food stamps, which is also covered under a social services, under social services, as well as Medicaid, also known as New Jersey Family Care. Again, a lot of those applications are processed by the local social services agencies, Social Security, and our more upcoming recent practice in unemployment insurance benefits. And then we will address any questions you may have after the presentation. So generally, we handle welfare, TANF or GA denials, terminations, reductions, overpayments, suspensions, or intentional program violation notices. So TANF stands for Temporary Assistance to Needy Families, and GA stands for General Assistance. Emergency Assistance, also known as EA. One of the programs under emergency assistance is TRA, which is Temporary Rental Assistance. We handle denials and terminations. Under food stamps, we handle denials, terminations, reductions, overpayments, suspensions, or intentional program violation notices. Medicaid, also known as New Jersey Family Care, denials, terminations, overpayments, or reduction in services, such as dental services, home health aid services, and private duty nursing. Some of these areas will either be full representation or advice only. And we also handle SSI, a combo of SSI, SSD disapproved claims or solely SSI claims, notices of reconsideration, suspension, terminations or overpayment notices, Social Security disability cessation notices, termination of benefits, and more recently, unemployment insurance benefits cases. So now discussing Work First New Jersey, which is welfare that's under the purview of social services. Social services in cases can provide cash assistance under temporary assistance to needy families, or GA, general assistance for adults without minor children. And eligibility for this cash assistance program includes financial and non-financial considerations. So some of the non-financial considerations that the social service agency will look at is relationship of the individuals, age, citizenship or immigration status, child support cooperation, cooperation with work requirements, residence in the state, county, or municipality, and then we'll assess their financial need by looking at what their income source is, if any, or any resources that they may have, if any. Cash assistance is a time-limited program. It's a 60-month lifetime limit. There are exemptions, so individuals over 60, a caretaker relative of disabled child or dependent who needs full-time care, someone who is considered permanently disabled, chronically unemployable, or subject to domestic violence. All adults who are able to work must participate in a work program up to 35 hours per week. If these requirements are not met, there are potential sanctions that recipients of cash assistance may be subject to. If there is no work requirement for those who have a medical form known as the Med-1 filled out for 12 months or more, they are exempt from the work requirement as long as they have this medical form filled out. And just to give you one idea of what the cash assistance amount are for, the number of people on the grant, or whether they are considered an employable or unemployable adult, you can take a look at the graph and note that the cash assistance amounts are not particularly high. And so we find in our practice that the biggest benefit of receiving cash assistance are some of the supplemental services that social services can provide, such as emergency assistance, which is essentially the housing assistance. So speaking of supportive services for Work First New Jersey families and working families, these services are tied to your eligibility for cash assistance. So they may include transportation, childcare, work-related expenses, and services that are not tied directly to work are Medicaid, New Jersey Family Care, food stamps, and childcare for special circumstances. Ordinarily, clients who go and apply for social services usually get assessed for all these different supportive service programs. So a lot of our clients will already come in with having applied for food stamps or having applied for Medicaid. Generally, that does not get missed in terms of applications with social services. One of the biggest supportive services, as I was saying earlier, is emergency assistance, which is known as EA, and that's generally how we refer to it. And this is housing, shelter, utility assistance in emergent situations. There is also assistance with related emergent expenses such as food, clothing, furniture, transportation to search for housing, and moving expenses. Who is eligible for this supportive service? If you are a cash assistance recipient, whether GA or TANF, or otherwise Workforce New Jersey eligible, or an SSI recipient. Social Security disability insurance recipients are not eligible for emergency assistance. That being said, just having cash assistance or SSI doesn't necessarily equate to mandatory EA. EA approvals are subjective based on the following criteria: loss of housing, utilities, such as due to disaster, homelessness or imminent homelessness, due to circumstances beyond the recipient's control, or recipient lacked the realistic capacity to plan in advance for substitute housing, or functional incapacity. We see that emergency assistance is denied in the following circumstances, which can incur a 6-month penalty, which means that if someone is denied for any of these reasons, there is a 6-month penalty that carries where that person is not eligible for emergency assistance for 6 months, at which point they can reapply for emergency assistance. And the following reasons for that penalty would be if through employment there was a voluntary quit, they caused their own homelessness without good cause, whether that be refusal to accept affordable housing, eviction due to criminal activity, eviction due to destruction of property, had the available funds and capacity to prevent homelessness, the applicant or recipient's behavior directly caused eviction, abandoned affordable housing, or failure to comply with a service plan. So that can be the service plan tied to the cash assistance. Even though that is daunting that there are so many reasons why you could be denied, there is an assessment that social services does where if it's not your fault that you happen to be without housing due to domestic violence, or there's child protection involved, and they can certify to the Division of Family Development, which is the state agency that oversees all of the social services agencies in New Jersey. And the child protection can certify that placement of children in foster care is imminent due to lack of housing. Social services can overlook sort of any mishaps and be able to provide emergency assistance. Or if housing is needed for under the DCP&P reunification plan, and it's specified in the plan. So that should read plan, not plant, or other DCP&P document. There are, just as there are time limits for GA, there are time limits on EA. Time limits for EA are 12-month lifetime limit on receipt of EA. There are extensions available. Under the TANF grant, TANF recipients may receive up to 2 6-month extensions of EA for a maximum of 12 months in cases of extreme hardship. So it winds up being 24 months or equivalent to about 2 years. Examples of extreme hardship include danger of loss of employment, imminent danger of family breakup with children needing foster care placement, imminent physical danger or risk of abuse and neglect, danger or serious harm to a mentally disabled or physically disabled recipient. Oops. There is also, in limited circumstances, some disabled individuals can continue to receive EA beyond time limits. The most recent enacted extension is under the Emergency Assistance for Specific Groups extension, which reflects previous extensions, or the individuals that would qualify for this extension. So EA can be extended without a time limit to eligible individuals in the following circumstances. The parent or other relative of a disabled child or other disabled dependent who must provide full-time care for their disabled child or other disabled dependent. Permanently disabled, which can be sort of not proven, but a Med 1 would be required, and stating that the person is unable to work for 12 months or more in order to qualify for this extension. So that is the most common extension that we see. Someone who is over the age of 60 or someone who is chronically unemployable. If there is a denial or termination of benefits, a fair hearing can be requested. So there is a 90-day deadline to request a fair hearing, a 15-day deadline to request a fair hearing with continued benefits if you are a current recipient of either cash or any of its supportive services. If you request an emergency fair hearing, the fair hearing will usually be scheduled within 3 days, and it's usually requested for those facing imminent homelessness. Hearings are held before the Office of Administrative Law, and the final decision is made by the Division of Family Development. Fair hearings used to take place in whether an administrative building of the county, in person, but more recently, since the pandemic, fair hearings take place over the phone, and it's very rare that any of these fair hearings take place in person nowadays. Okay, so moving on to the SNAP program, which is a separate program from the cash assistance program. Eligibility is available to households meeting the non-financial criteria. There will be certain groups that are ineligible, such as certain immigrant statuses, able-bodied adults without dependents, disqualified due to intentional program violations, strikers, and some students. You must also meet the financial requirements for SNAP. You must meet the gross income test, and that should read test, not text. Must meet net income test after allowable deductions, and must qualify for SNAP allotment based on net income, and also must meet the resource test in order to qualify for SNAP. You apply for that at your local county social service agency. They will take down the information, do the calculation as to how much SNAP you would be eligible for. In New Jersey, the minimum amount of SNAP is about $95. That includes a supplement by the state that only the state of New Jersey has decided to give, and that will hold until about the beginning of the year. And at that point, it may either continue or it may change. Medicaid eligibility is under 6 basic categories. Generally children, adults with dependent children, adults without dependent children, pregnant women, disabled, or elderly, and there are different financial eligibility for each category. You can apply for Medicaid through your local county welfare agency. There is also the NJ Family Care website where families or individuals may apply. And I provided the website and the phone number as to where you can obtain more information. There has been somewhat of a disconnect with some of the Medicaid cases, specifically for older adults who are transitioning off of SSI onto either early Social Security retirement or maybe a survivor benefit through Social Security. It seems to be somewhat of a bifurcated system where the phone line handles some forms of Medicaid and the county welfare agencies only handle some forms of Medicaid. But that being said, if any of your clients are facing any Medicaid issues, either are denied or terminated, our office can look into what those reasons are. There is also a fair hearing that you can request through the Division of Medical Assistance and Health Services. Those cases are also seen by the Office of Administrative Law. Same with food stamps. You can request a fair hearing if you are denied or terminated food stamps. Same thing with Medicaid. Denied or terminated, you are eligible to request a fair hearing to contest the reasons for the denial or the termination. And our office can help assist clients who are in need of guidance in that regard. So now moving on to Social Security. There are two different programs that I will discuss today, probably going more into supplemental security income. There are differences between the two programs. So under Social Security disability insurance, that is the money that gets set aside in your check that you contribute to the Social Security Administration in the event that you should become disabled. You have sort of that insurance available to you, assuming that you meet the eligibility criteria. The Supplemental Security Income Program is for those individuals without a work history or not enough work history to claim Social Security disability insurance. We generally only ever will take cases for someone that's dual eligible, so SSI, SSDI, or just an SSI case. The reason why someone may be dual eligible for SSI and SSDI is that there's sort of a cap amount that must be met. And so if the person doesn't have enough Social Security disability insurance to meet that cap, supplemental security income will get that person to that cap, which is roughly $975. So in order to qualify for supplemental security income, there's a couple of ways that a person may qualify, either by age or through or by being disabled. There's a couple of phases of the program. So you will file an initial application, at which point, if it's approved, great, there's nothing to discuss. If you're not approved, there will be an initial decision, at which point you have 60 days to request reconsideration. And the request for reconsideration is a review of whatever medical documentation that Social Security has at that point. Generally speaking, we find that a lot of cases are denied at the reconsideration level, especially if the record that Social Security has is not updated, at which point our office does get involved at sort of the second level of appeal, which is to request a hearing before an administrative law judge through the Office of Hearings Operations. In terms of Social Security disability, we would handle cessation cases. So where someone is being terminated on generally a continuing disability review, which is where Social Security is saying, you are now better and now you can work. And so you are no longer eligible for Social Security. When you file a claim for Social Security, you're essentially stating that you are permanently disabled or over a certain age. We handle overpayments, so that may be the case where, and we will sort of discuss this a little bit more later, but under the SSI program, one of the other distinctions of this program is that it's resource-based. So individuals receiving supplemental security income, if it's just one individual, may not have more than $2,000 in resources. And so anytime you are $1 above those $2,000 resource limit, is a month that you were not entitled to receive SSI, and that's how you wind up incurring overpayments. The Office of Hearings Operations was formerly known as ODAR, holds administrative law judge hearings. And these administrative law judge hearings previously were held in person. For the Morris County region, those hearings were generally held in Newark. But nowadays, most of our clients, most claimants prefer telephone hearings or video conference hearings. In-person hearings are still requested, but they're not as common for a lot of our clients. Transportation is a huge issue. So telephone hearings or conferencing over video is generally more convenient for our clients. And it has not been shown to negatively impact their success rate. After the Office of Hearings Operations level, the case can be appealed to the Appeals Council. And then the level after the Appeals Council, if you are not successful, is to go to the United States District Court of Appeals. So just to talk a little bit more about the distinctions between Social Security disability insurance, also known as Title II, pays benefits to people who are disabled and unable to work with a sufficient work history regardless of their income and resources. Supplemental Security Income, also known as SSI, and Title 16 to Social Security pays benefits to people who are disabled and unable to work who have limited resources and income. So for instance, you see a graph here, sort of kind of a different way of looking at it. SSI carries a resource limit. Benefit amount is subject to change based upon circumstances. SSI recipients will automatically be eligible for Medicaid. And this Medicaid is not the same as the state Medicaid programs that I sort of briefly mentioned. Under Social Security disability insurance, you must have the requisite work history. There is coverage for dependents and survivors. There's a bit of a waiting period. Benefits are payable prior to the date of the application, and you would eventually be eligible for Medicare. So filing an initial application for either SSI or SSDI or both, you can do in one of three ways. You can go online and file your application. You can go in person, or you can apply by telephone. Generally, we find that even for in-person filing, depending on the local office, you may actually have to schedule an appointment to actually go in person, especially since the pandemic. So we find that filing online or by phone generally tends to be the easiest way of initiating an application. You will receive an initial decision. You'll either be approved, which at that point you will start to receive benefits. If you're denied, then the case will go to the reconsideration level, which means that the Social Security Administration will just review everything on the papers. There's no hearing. They're just re-looking at the record to see if anything was missed or any new information has been received. At the point where we generally get involved is where there's an administrative law judge hearing. And so that is the phase after reconsideration. So after reconsideration, you will receive a decision. At that point, you will have, in any of these appeals, you always have 60 days to appeal. If you miss that deadline, but have good cause, you should still file an appeal, documenting what your good cause reason was. Generally speaking, that tends to be health related. I was in the hospital, or there was homelessness involved, and so the person didn't receive the notice on time. For administrative law judge hearings, the cases will be reviewed, not factoring in any of the prior decisions. They review it with fresh eyes, and you have the opportunity to submit new evidence, which if you are represented by our organization, we build up the case. So we request your records. we submit them into the electronic records system that the Social Security Administration has for these cases. And hopefully what winds up happening is that we are successful and a person will obtain benefits. If we are not successful, there's always the appeals council level, which is still sort of an administrative appeal that's still under the arm of the Social Security Administration. If that is unsuccessful, there is the opportunity for federal court review, and that is something that we would review with our higher ups, with management, to see if it's a case that we would take to that level. Or someone can just actually reapply. So that is always an option in these cases. So the definition of disability for adults is the inability to engage in any substantial gainful activity by reason of medically determinable physical and or mental impairments, which can be expected to last for a continuous period of not less than 12 months or result in death. And there's a 5-step sequential evaluation that takes place specifically at the administrative law judge level, where the analysis is the applicant engaging in substantial gainful activity? Generally speaking, that's more than just a part-time job. Step 2, does the applicant have a severe impairment? So is there either a physical or a mental impairment involved? Do they suffer from an impairment which meets or equals the severity of a listed impairment? That's step 3. And then step 4 is, does the claimant have the residual functional capacity to perform past relevant work? Step 5 is, does the claimant have the RFC to perform any other work in the national economy? So in each administrative law judge hearing, you are trying to either show step 3, that they meet or equal the severity of a listed impairment, or step 4 or 5 in order to succeed in the case. And just as just for your information, the Social Security listing of impairments will go sort of by body system. So you'll see the musculoskeletal system has its own category, special census too, and so on. And you can see from here that it has most of the body systems. And these are the sort of under the mental health disorders, which is the category under 12, they have the different diagnoses. So under neurocognitive disorders, schizophrenia, depressive, bipolar, and related disorders. So it goes a little bit into more specific as to the particular diagnosis, at least under this category, and it would be the same for the other systems. Okay. So just to go back a little bit more, just to explain that at the administrative law judge level, we are trying to show that a claimant, again, meets or equals any of the listings that you saw, whether physical or mental, through medical records and through their own testimony, and anyone who has sort of third-party individuals who have observed any of the symptoms that a claimant may be experiencing. If that is not persuasive enough, because it is very difficult to actually meet or equal a listing, you want to be able to show that at the maximum capacity of this person, they would not be able to do past relevant work if it's applicable, or that there would be no work in the economy that this person could do with the kind of limitations that they are facing. So for unemployment, which is our upcoming work that we are entering, generally speaking, to be eligible, a person has to show that they're ready, willing, and able to work. And to be able to, they also must consistently report weekly this eligibility requirement that they're ready, willing, and able to work and still have not located employment. There are disqualifications, such as misconduct and voluntary quit, that would disqualify someone from receiving unemployment. And our office will be addressing those unemployment benefits insurance cases, hopefully in the next couple of weeks. And the general levels of appeal are, if you disagree with the disqualification, you will be scheduled for a deputy interview and they will review the allegations of why you have been disqualified. Generally speaking, they uphold the decision below, at which point claimant would have the ability to appeal at the appeal tribunal, which is a telephone hearing before someone, a hearing officer at the Department of Labor, and you will argue why the disqualification criteria has not been met. If you are successful, then you will claim all those unemployment benefits that you've been claiming on a weekly basis. If you are unsuccessful, you will still have to continue to report for unemployment and have a chance to appear before the Board of Review. And they will, it's not a hearing, they just review the appeal tribunal's decision and your argument, and then we'll make a final decision based on that. If you are successful, great. If you're not successful, your next level of appeal is to the appellate division. So I know that that's very fast in terms of unemployment, but that's generally speaking how we are planning on addressing unemployment issues. And so, are there any questions?
We will open it up for questions in one moment. I'd just like to thank Yvonne for joining us today and sharing this information. And I'd like to thank all you who joined us and took the time out of your day to come and listen to the presentation. For anyone that would like to share this presentation, it will be up on the Family Partners YouTube channel early next week. At this point, I'll stop the recording and we'll open it up to questions.